"You don't belong in this courtroom. Not dressed like that." The bailiff said it low, almost under his breath, but Miriam heard every word. She had been hearing words like that her whole life. She set her coffee cup on the edge of the bench, smoothed the front of her plain navy blazer, and looked at him the way she always looked at people who assumed things, quietly, patiently, like a woman who knew exactly how this ended. The bailiff's name was Doyle. He was broad-shouldered, 20 years on the job, and absolutely certain he was looking at someone who had wandered in from the wrong floor. She didn't have a briefcase. She didn't have a lanyard or a badge clipped to her lapel. She had a cup of coffee, a pair of flat shoes, and a gray blazer that had seen better days. Doyle had worked federal court long enough to know what power looked like. It looked like tailored suits and leather portfolios and men who shook hands with both hands. It did not look like this. "I have a hearing at 9, Miriam said. Doyle didn't move. "Ma'am, this is a restricted floor. Federal proceedings only. If you need the public gallery, it's one level down." "I know where the public gallery is," she said. "I need to be here." He almost smiled. "Okay, name," she told him. His pen stopped moving on his clipboard. He looked up. He looked back down. He looked up again. He cleared his throat. "That doesn't match what I have here." "That's because what you have is the docket," she said. "And I'm not on the docket. I'm running it." 30 seconds later, Doyle stepped aside. He would spend the rest of the morning rearranging his face into something that didn't look like what it was. A man who had just made the exact mistake he would have told his own son not to make. But that was how the day started. It rarely started any other way. 2 hours earlier, the Hargrove family had assembled in the lobby of the Belmont Federal Courthouse, like a small army of pressed linen and controlled expressions. There were 11 of them, including spouses. They came from old Chicago money, the kind that didn't talk about where it came from because it had been there long enough to simply be there, the way furniture is. At the center of it was Theodore Hargrove. He was 63, silver-templed, and carried himself the way men do when they have spent decades being the smartest person in rooms they arranged themselves. His law firm, Hargrove, Strand and Bellamy, occupied the top 4 floors of a building he partially owned. He had argued before the 7th Circuit 11 times. He had won 9 of those. He reminded people of this often enough that it stopped sounding like pride and started sounding like a nervous habit. Beside him stood his wife Camille, who wore pearls to a 9 o'clock Federal, hearing the way other women wear them to brunch, easily, without thinking. She had the polished, impenetrable look of someone who had long ago decided that being warm was a choice she would make strategically. And then there was their son, Bennett. Bennett Hargrove was 34. He had his father's jaw and his mother's composure and, on this particular morning, the look of a man who had not slept in 3 days. He stood slightly apart from the rest of the family, which was the only honest thing in the lobby. Next to him stood his wife. Her name was Lydia, but she wasn't in this story, not yet. The woman next to Bennett was named Opal Reese Hargrove, 38 years old, brown skin, natural hair pulled back simply, no jewelry except a thin silver band on her left hand, clothes that fit well but didn't announce themselves. She looked like a woman who had made peace with being underestimated. She looked like a woman who had been practicing that particular piece for a very long time. Theodore noticed her the way he noticed furniture that wasn't where he'd put it, with a slow, displacing frown. She had been married to his son for 3 years. 3 years, and Theodore Hargrove still had not learned to look at her without that frown. The lobby was marble and glass. A security checkpoint hummed at the far end. Somewhere above them, courtroom 14B was filling with clerks and attorneys and the particular quiet of a room waiting to become important. Theodore pulled Bennett aside near a column, his voice dropping to the register he used for things he didn't want recorded. "I need you to be sharp today." He straightened Bennett's collar in a gesture that was too practiced to be affection. "This is the Caldwell hearing. Everything we've built toward it. Don't be distracted." His eyes moved briefly to Opal, who was standing a few feet away looking at her phone with the calm of someone who had already read everything worth reading and was simply waiting. Bennett said, "I'm not distracted." "Good." Theodore dropped his hands. "Then we shouldn't have any problem." He said it like a man who expected the answer to every problem to be yes. He had no way of knowing that the one person in that lobby who could solve his problem or end his career was standing 4 feet away in flat shoes, holding a coffee cup she hadn't finished. The Caldwell matter was not a small thing. It was a federal civil rights complaint, filed on behalf of 9 plaintiffs who alleged systematic discrimination in hiring and promotion at Hargrove, Strand and Bellamy over a period of 11 years. The kind of case that ended firms. The kind that made names or erased them. The case had been assigned 7 weeks ago, and the assignment had been handled quietly, the way sensitive things are handled in institutions that understand that transparency is not the same as publicity. Nobody outside the court's inner administrative circle knew who the presiding judge was. Theodore Hargrove, in 31 years of practice, had never lost a case he controlled the room on. He believed today would be no different. He had prepared for every judge on the shortlist. He had notes, histories, temperament profiles, documented rulings. He was, in every sense, ready. He was ready for the wrong thing entirely. Opal had known for 6 weeks. She had not told Bennett because Bennett would have told his father, and Bennett's father would have done something. She didn't know what, exactly, but something, to turn it into an advantage or a problem or both. Theodore Hargrove treated everything as a chess piece. She had stopped being surprised by this. She had simply stopped letting him know where the pieces were. She put her phone in her pocket when the elevator opened on the 14th floor. Bennett touched her arm. "You okay?" She smiled at him. "I'm fine," he always asked. Even when the asking cost him something with his family, he asked. That was the thing about Bennett that his father had never managed to calculate out of him. "I'm fine," she said again. "Go be with your family. I'll be in the gallery." He held her gaze for a moment. "You sure?" She squeezed his hand. "I'll see you after." She watched him walk toward his father, watched the way his shoulders changed slightly when he crossed that invisible threshold. The one all children of difficult men know by instinct. She understood it. She had her own versions of those thresholds. Then she turned and walked the opposite direction, down the hall toward the chamber's entrance. Doyle had already cleared her. Inside courtroom 14B, the Hargrove family took their seats behind the bar. Theodore arranged his files with the precision of someone who knows that every visible action communicates something. His 2 senior partners, Philip Brandt and Roland Cheever, spread out beside him in dark suits that cost more than most people's rent. The gallery filled slowly. Clerks, junior associates, a court reporter, 2 people from the plaintiff's side who sat quietly and didn't speak to each other, the way people do when they have decided that everything worth saying has been filed already. Theodore looked at the bench, still empty. He checked his watch. 3 minutes to 9. Camille leaned forward from the gallery and murmured something low. Theodore nodded without turning around. Bennett sat still, watching the empty bench with an expression his father could not read. Then the side door opened. A clerk entered first, adjusted 2 chairs, set a water glass. Then a second clerk. Then nothing for a moment. Then Miriam walked in. She moved without hurry, the way she always moved, with the particular unhurriedness of someone who has never needed to prove they belonged in a room by arriving with urgency. She was wearing the navy blazer. She had finished the coffee. Her hair was natural, close-cropped, unadorned. No robes yet. Those would come, but the way she crossed to the bench made the room shift anyway. She was compact. She was quiet. She looked, to anyone who didn't know, like someone's assistant coming to check a microphone. Theodore's eyes tracked her with mild professional attention. Then she sat down. Then a clerk said, "All rise. The United States District Court for the Northern District of Illinois is now in session. The Honorable Miriam Osia-Chimpong presiding." The room rose. Theodore Hargrove's hand stopped moving on his notepad. Philip Brandt looked at Roland Cheever. Roland Cheever looked at his shoes. Theodore looked at the woman behind the bench. She was unfolding her reading glasses with the composed ease of someone who had sat in this chair more than 400 times. She opened the case file. She did not look up immediately. She let the room settle the way she always did, because rooms needed a moment, and because she had learned that the silence itself communicated something to people who paid attention. Then she looked up. Her eyes moved across the courtroom without hurry, taking in the gallery, the clerks, the plaintiff's table, and then the defense table, where Theodore Hargrove sat with his 2 partners, and the particular stillness of a man whose internal machinery had just ground to a halt. She had met Theodore Hargrove exactly once, at a bar association dinner 6 years ago. He had spoken to her for approximately 90 seconds before his attention moved elsewhere. He had later described the evening to a colleague as efficient. She knew this because the colleague had told her. She had not been surprised. "Good morning," she said. Her voice carried to every corner without effort. "We're here on Caldwell versus Hargrove, Strand and Bellamy. I've reviewed the submissions. Before we begin, I want to make something clear." She looked directly at the defense table. "This court has zero interest in delay tactics, procedural obstruction, or requests for recusal premised on prior acquaintance. If there are preliminary motions of that nature, file them in writing by end of business today. I will review them and rule by morning. If there are not, we will proceed." She paused. "Is there anything from the defense before we begin?" Theodore's mouth opened, closed. His hand, which had stopped on the notepad, moved again, but differently, like a man writing a note to himself about a situation he had not prepared for. "Your Honor," he said carefully, "I wonder if, given the family connection, the connection you're referring to," Miriam said, "is that your son is married to my former law clerk." A sound moved through the gallery, not loud, just present. "I am aware of that connection," she continued. "I disclosed it to the Chief Judge's office when the assignment was made. It was reviewed. It was determined to be non-disqualifying. If you have contrary authority, I expect to see it in writing by 5 o'clock. The briefest silence. No motion was filed. Theodore sat down. He did not do it gracefully. He did it the way a man sits down when his legs have made a decision his brain is still processing. Beside him, Philip Brandt leaned in and said something very quietly. Theodore shook his head once, a small, tight movement. Roland Cheever opened his own notepad and stared at it. In the gallery, Camille Hargrove had the expression of someone who has been handed a document in a language she does not speak. She sat perfectly still, pearls in place, face arranged, working very hard at the composure she had spent 60 years building. Bennett sat 2 seats away from her. He was looking at the bench. His face had an expression that, if you knew him, you might have called relief. The hearing ran 2 hours and 40 minutes. Miriam did not raise her voice once. She did not need to. She asked questions that were precise and patient, and went exactly where she intended them to go, like a woman who had read the transcript of a conversation before it happened. When Theodore attempted to redirect, she redirected him back. When Philip Brandt tried a procedural maneuver that was technically permissible and practically transparent, she permitted it and then dismantled it so cleanly that the court reporter paused for just a moment before continuing to type. The plaintiff's attorney, a woman named Dorothea Shen, who had driven 4 hours from Milwaukee for this hearing, said almost nothing. She didn't need to. She had filed well, and the judge had read it, and some mornings in a courtroom that is enough. At 12:47, Miriam set down her pen. She looked at both tables. Then she looked specifically at Theodore Hargrove, who had been practicing law since before Miriam Osi-Achimpong had started law school, and who had never once, in 31 years, sat across from anyone who made him feel the way he felt right now. She said, "I've heard enough for today's preliminary matters. I'll have written rulings issued within 72 hours. Counsel will be notified by the clerk's office." She closed the file. She removed her glasses. "One more thing," she said, and her voice was the same as it had been all morning, even, unhurried, carrying to every corner. "This case is about whether the people who walked through your firm's door over 11 years were treated as professionals or as furniture. The record suggests a clear answer. I want the defense to understand that I have read every document submitted, including the internal communications produced in discovery." She stood. Every phone in the room that had been held discreetly under tables was at that moment very still. "This court will hold all parties to the same standard," she said. "The law does not read nameplates before it decides who it applies to." She walked out. The side door closed behind her. The room exhaled. Theodore Hargrove did not move for a moment. Then he reached for his water glass, and his hand, the steady, practiced hand of a man who had cross-examined witnesses for 3 decades, was not entirely steady. Philip Brandt was already on his phone, walking toward the hall. Roland Cheever gathered files with the contained speed of a man who wants to be somewhere else. The gallery cleared in the way galleries clear when something has happened that people need to process alone. Camille found Bennett near the door. She reached for his arm. "Bennett," she said. Her voice was still composed, but something in it was asking a question she didn't know how to form. He looked at her. "Did you know?" she said. "About Miriam being assigned to the case?" He paused. "No, a beat." "About who she was?" Camille asked. He looked toward the door his father had just gone through. "Yeah," he said. "For a while now." Camille's hand dropped from his arm. "She was my law school classmate," Bennett said. "Before she was anything else. Before the clerkship, before the appointment. Opal met her first. She thought I should know her, and she was right." He picked up his jacket from the chair where he'd left it. "Dad never asked," he said. 3 years and he never asked Opal a single question about where she came from, or who she knew, or what she'd done before she married me." He looked at the empty gallery, the cleared bar, the bench where a woman in flat shoes had just rearranged the next 6 months of their lives. He decided what she was before she opened her mouth. He glanced at his mother one more time. "She told me the day she matched to the federal clerkship," he said. "I remember she was eating a sandwich in our apartment, and she looked up and said, 'I got it.' And I said, 'Got what?' And she said, 'The thing I worked for.' Turns out that thing was this courtroom." He walked out. Camille stood in the empty gallery for a moment. Then she sat down in one of the chairs and stayed there. What happened next was not immediate. These things rarely are. Theodore filed a recusal motion by 5 that afternoon. It was thorough and well-argued, and premised on a reading of judicial ethics that was technically coherent and practically doomed. Miriam reviewed it by 7 the next morning and denied it in writing by 9, citing the Chief Judge's prior review, 3 circuit-level precedents, and one line at the end that was the calmest devastation in 12 words. "The motion does not identify an impropriety. It identifies a surprise." The ruling circulated among the local bar within 24 hours. Law clerks sent it to each other. Someone posted the last line on a legal forum without attribution. By the weekend, attorneys in 3 states had read it. Dorothea Shen called it the most economical denial she'd seen in 15 years of practice. The Caldwell case proceeded. It took 9 months and ended in a settlement that Theodore Hargrove agreed to on a Tuesday afternoon in November, in a conference room that was not his and at a table where he was not at the head. The terms were sealed, but the agreement included a mandatory third-party audit of all hiring practices at the firm, a public statement of accountability that was to be posted to the firm's website, and a restructuring of its internal review processes. It also included, at the insistence of the plaintiffs, a paragraph that was unusual, a requirement that every incoming associate at the firm receive during their first week a session on unconscious bias evaluation. Not a pamphlet, not a checkbox, a session. The firm partner who argued hardest against that paragraph was Theodore. The partner who argued hardest for it was Bennett. Bennett won. He had not, until that moment, won many arguments with his father. He did not celebrate. He sat in the conference room after everyone else left, in a chair that was slightly too low for the table, and thought about the fact that winning against his father felt less like victory and more like a door he had, finally, after 34 years, walked through. On the other side was a room he didn't know yet, but it was his. Opal was waiting for him in the lobby. She had brought 2 coffees. She handed him one without a word. He took it. They stood together by the glass doors and watched the November street outside, gray and sharp, the trees down to their last few leaves. "I heard it went okay," she said. He looked at her. She looked back. He said, "Did you know she'd be assigned to this case?" She took a slow sip of coffee. "I knew she was in the pool," she said. "I knew the case was in the Northern District." She paused. "I didn't know it would be her." He nodded slowly. "But if it was going to be anyone, she said. He thought about the conference room, about the 9 plaintiffs whose names were on the filing, whose names he had read over and over in the documents until they stopped being case references and started being people. A recruiter who applied 6 times and was told each time the position was filled, a paralegal with 17 years of service who was passed over for promotion 11 times in favor of people with fewer years and different faces. He thought about Philip Brandt's expression when the settlement number was put on the table and he realized they were going to sign it. He thought about his father, sitting in that same conference room, 4 hours into the session, looking older than he had looked that morning. He said, quietly, he never asked her anything. 3 years, and he treated her like... He stopped. "Like furniture," Opal said. The word landed without heat, which was somehow worse. Like she'd said it before. Like she'd had to decide what to do with it. He looked at her. He said, "I'm sorry." She said, "I know." He said, "Not enough. I should have said it more. I should have said it louder and earlier and in front of him." She looked out at the street for a moment. The light changed. A taxi pulled away. "You chose me," she said. "When it mattered, you chose me," he said. "That's not enough either." She turned to look at him, and something in her face settled into the expression he knew best, the one that had no performance in it, no calculation, just the clean, direct look of someone who sees what's actually there. "It's a start," she said. They drank their coffee. The street was cold and the trees were nearly bare, and the courthouse was 3 blocks away, solid and gray against the November sky. Theodore did not apologize. Not in writing, not in the room, not to Opal, not to the 9 plaintiffs whose names he had learned eventually, but too late for the learning to mean what it might have. What he did was something smaller, and it happened 6 months after the settlement, on a Saturday in May, when Bennett brought Opal to a family dinner that Theodore had not found a reason to cancel. He did not greet her the way he always had, which was with a nod that did not quite reach his eyes and a comment about traffic. He stood up when she walked in. Just that. He stood up. Opal noticed. She did not say anything. She sat down and asked about the garden, which was Theodore's one genuine pleasure outside the law, and he answered, briefly at first, then longer, because it was the garden, and no one ever asked about the garden. It was not a reconciliation. It was not a reset. It was one man standing up, which he should have done 3 years ago, and a woman deciding what to do with a gesture that came late. She let it sit on the table. She didn't take it back, and she didn't hand it back either. She left it there, the way you leave something unfinished in a place where it might eventually, if everything went reasonably well, become something else. Miriam O.C. Achimpong returned to her work. She had 4 other active cases that week, a law school panel to moderate in March, and a brief she'd promised to review for a former student who was arguing before the 7th Circuit for the first time. She did not give interviews about the Caldwell case. She did not post about it. She did not discuss it at dinner parties, which she attended infrequently, or with friends outside the law, who knew better than to ask. She was, by every available measure, exactly who she had been before she walked through the door of courtroom 14B, a federal judge in the Northern District of Illinois, assigned there by appointment, confirmed by the Senate, invested in the work in the way people are invested in things they chose because the choosing mattered. What changed was other people's knowledge of her. The bailiff Doyle passed her in the hall 2 weeks after the hearing. He stopped. He looked like a man preparing a speech he hadn't finished writing. "Ma'am," he said. "I want to say," she stopped him gently. "It's all right, Doyle." He shook his head. "No, Your Honor, it isn't. It really isn't." She looked at him for a moment. He was being sincere, she could see that. There was a particular quality to sincerity that was different from apology and different from performance, and she had learned to tell them apart a long time ago. "No," she agreed. "It isn't. But you can do better from here." He nodded. She went back to work. Here is the thing about a story like this one. It's easy to hear it and feel the satisfaction of the ending, the settlement, the ruling, the moment in the lobby when Opal handed Bennett a coffee and they stood together in November and talked like 2 people who had survived something. It's easy to think, justice, and some of it was. But Opal went into that lobby 3 years ago as a lawyer with a federal clerkship under her belt and a record that any firm in the country would have hired without hesitation, and she spent 3 years being looked at like furniture in her own family. Not by strangers, by the people who were supposed to be hers. She didn't have a plan for Miriam. There was no scheme, no waiting, no strategy. She had a husband who loved her, a former colleague who happened to be brilliant and appointed to the bench, and the patience of a woman who has survived long enough to understand that truth doesn't need a dramatic entrance. It usually just needs time, and a door that opens at the right moment. What I keep thinking about is the table. Not the courtroom, not the ruling, not the part with the settlement numbers. The table at that Saturday dinner in May. Theodore standing up. Opal deciding what to do with a gesture that came too late to be full credit, but maybe not too late to count as something. That's the part none of the legal filings capture. That's the part no transcript holds. What do you do with a gesture like that? What do you do when the person who got it wrong finally, halfway, starts to get it right? I want to hear what you think. Drop it in the comments. I read them all, and this is one of those questions I don't have a clean answer to, Because I think the answer depends on who you've been and what it cost you, and whether the person doing the standing up understands what they're standing up from. If this story landed somewhere real for you, share it with someone who needs to hear it. Subscribe for more, because there are more stories like this one. Stories where the quiet person in the room is holding more than anyone thought, where dignity turns out to be a longer game than power, where what looks like nothing is sometimes everything. The woman in the flat shoes is almost never who they think she is. Pay attention.